convicted of the offense of dealing with the suspect property contrary to Section 21 of the Anti-Corruption Act. The law provides that upon conviction, the offender is liable to a fine not exceeding 160 currency points or to imprisonment to a term not exceeding 7 years or both.
150 currency points?
160 currency points.
That translates to what in terms of real cash? London currency? I like to think in the real sense. That is what?
3,200,000 shillings. Okay. My lord, the convict is a first-time offender to the knowledge of the prosecution. However, as the sentencing guidelines make it clear, the mere fact of being a first-time offender status does not diminish the gravity of an offense where circumstances disclose high culpability and significant aggravating features. My lord, in assisting this honorable court to arrive at an appropriate sentence, the prosecution is guided by the constitutional, in brackets, sentencing guidelines for courts of judicature, practice directions 2023, particularly the provisions relating to the purpose of sentencing, the general sentencing principles, and the factors aggravating corruption and related offenses. The aggravating factors, my lord, in this matter are not only numerous but deeply compelling. First, the offense was committed in clear abuse of office and breach of public trust. The convict at the time of the offense was a Minister of State for Karamoja Affairs and remains a serving woman member of Parliament for Bududa District. This position, my lord, placed upon her judiciary duty of the highest order in relation to public resources. Instead of safeguarding those resources, the convict diverted them for her own use. My lord, this conduct falls squarely within the aggravating consideration of breach of trust and abuse of office, which the guidelines recognize as central in corruption-related offenses. My lord, the trust breached was not merely institutional, but extended to intended beneficiaries, namely the Karachunas and the wider Karamoja community, who were deprived of resources meant for their welfare. Secondly, your lordship, the evidence establishes beyond doubt that the convict acted with corrupt intent and knowledge of the wrongful nature of her conduct. The manner in which the iron sheets were handled demonstrated a deliberate and calculated effort to conceal their origin and avoid detection.
The iron sheets which gave rise to this offense were returned. even the balance was paid for as per Defense Exhibit 2 and 3. What was not paid, my lord, were the army ships in the transit between the convict's farm and the police stores. And my lord, that order of compensation should not be visited on the convict, because the state evidence, particularly the investigations officers, confirmed that they carried the amities from the farm to the stores of police. And my lord, to be specific,
So that loss cannot be attributed.
it should not be attributed to the convict, my lord.
What did the convict pay for? Was it not? Remind me the figures that were recovered from the farm. I thought the payment to government covered the entire difference. Are we able to tell that this payment that was made covered this number of iron sheets in terms of quantity, so that then I can guide? It is okay. Please consult your client. Yes.
She says even those ones which was alleged to have been lost in the transit were also paid. And the farm and those ones which got phone were missing were also paid.
That's why I asked the question.
Yes,
Because I believe the compensation of the money that was paid should have been covering the difference of the iron sheets as per the police search records and what they got. That means if others got lost subsequently, still she has covered that.
The clarification has been made. It was, payment was made as per Exhibit D2 and D3.
Okay.
My lord, the submission by the state about the aggravating factors as per the guidelines, the convict, the mitigating factors has brought it out as against what the state has said. My lord, we invite you to weigh the mitigating factors by the convict defense against the aggravating factors by the prosecution. In this case, attracts a fine as first option or imprisonment of 7 years in default or both. My lord, we invite
Where
court.
is your interpretation of first option coming from? When you look at the provisions of the Act, where do you get that from? The reading of section 21.
Yes.
Go right there.
Well, the way I'm reading it says,
The way you're reading it, or what does it say?
any person who deals with property that she or she lives or has a reason to believe was acquired as a result of an offense and is acted as an offense and a conviction to a fine not exceeding 60 currency points.
Because it was placed first.
First.
All
That's
right.
how I'm looking at it.
Okay.
There's a chair here, but it is high. And the back is down.
Please continue, Council Nanda.
My Lord, as the convict has already stated, I just wanted to draw attention of court in respect of exit P12. The exit 12. My Lord, when you look at that exhibit P12, so many leaders have not received the iron sheets in the same manner.
I thought you were reopening
No, I'm not.
the question of the law, the facts upon which the conviction
No,
was.
I'm already mentioning.
So as per PX12,
Yes,
the recipients of the iron sheets were many.
well, many.
Okay.
Actually, my Lord, there are about 190 in the same manner. So, my Lord, we invite court to look at the circumstances and make a finding that several of them were also misled in the manner the convict was also misled.
About the health issue, yes, we've said that she has been sick, but as we speak currently, she's supposed to show us evidence, not just by word of mouth. They're supposed to bring medical evidence, which also shows that prison cannot manage her condition in the event that she's taken there. They've not produced any of that. My Lord, I also want to submit on the issue of return. The convict did not willingly return iron sheets. She did not wake up one morning and say, you know what, I was misled, let me return these iron sheets back to OPM. No. Police intervened, she was questioned, and led to the recovery of the exhibits. That's not willful return. And I don't want us to be caught in that misconception. My Lord, lastly, the issue of the compensation. I remember I saw the receipts which she brought in her defense, but unfortunately we've not verified. Apart from what she's telling us, I would really request for maybe time to also consult and know what exactly she paid for. Because if she's saying she paid for, we've had differences. What was recorded at the scene, what we verified in Chivoli, and at what point did she pay? So if she says, we would have no objection if she paid the difference of what police officials said had been missing, that way. But apart from having that receipt here, we did not verify. Because one, I think they gave us a photocopy, but we would need time to verify and know exactly what she paid for before we make our final announcement on that.
For the state and counsel for the defense, I've also carefully heard the submissions that have been made by the convict. I need some few hours to consider your submissions and prepare my written ruling, which I will deliver at 3 p.m. Counsel for the state, if you have any issue pertaining to the receipt for payments, I know they were tendered during the evidence of I know they were tendered into court during the evidence of the accused, and because she opted not to swear, you could not cross-examine on it. So, but still, I would have expected you to come prepared, because the aspect of payment certainly would affect proceedings of the nature that we are holding now. So if you want to address me, you will do that just before, and then I will determine whether it affects my decision or not. So allow me to return with my ruling at 3 p.m. today.
Thank you.